Are you a small business owner or entrepreneur that keeps running across these buzzwords when you're looking at signing a contract, and you're being asked to just sign the dotted line, but you keep wondering, what does this term really mean? Can somebody please explain this term to me? Well, then this video is for you, because in this video we're going to talk about some contract law buzzwords, if you will, or buzz terms, and what they really mean in simple speak. If you're new to the channel, go ahead and give this video a big thumbs up and click on the subscribe button down below. My name is Pam Matani. I'm a business lawyer and the founder here at Graphene Business Law, a law firm working exclusively with entrepreneurs and business owners throughout the province of Ontario, Canada. All right, so speaking of confusing contractual terms, the first term we're going to start with, again, in this educational video. The content being shared here is not legal advice. This is simply for educational and informational purposes, so that when you do get in front of a lawyer, you're able to ask much more meaningful questions, and through doing that, you're also able to save money in terms of the billable spent between you and that lawyer, because you'll be able to get to the heart of the contract, the terms that should most matter to you right away. And frustration in a contract is one such term. Now, what does frustration mean? As it might sound like in the colloquial sense, frustration, we're talking about a scenario where something, not to use the same word, but has been frustrated from taking place. In other words, where something is keeping something from taking place. But there's there's a sophisticated legal test that deals with that, and that helps the parties navigate in that courtroom setting, who's responsible for something, if any of the parties are, and what do we do with this new with this new huge inconvenience, or huge inconvenience that has taken place in the contractual dealings between the two or more parties. So frustration is a common law remedy. Of course, Ontario and most of Canada being common law jurisdictions, this will apply throughout the country. And again, with Graphene Business Law working with clients throughout Ontario, this will apply to any Ontario client. Frustration is a remedy that occurs, generally we see 4 triggering events for it to occur. And these are: 1, an unforeseen event occurring after the formation of the contract, right? So if you knew you're going to set up for a new commercial lease on top of this major seismic impact zone, and you knew that a huge earthquake is coming 5 months from now that's going to deplete your entire business and you won't be able to pay your landlord, well, that wouldn't necessarily qualify for frustration, because it's like you signed up for this. So frustration is a boo-boo that has to take place after the parties are signing the contract. So nobody knew or thought this could happen when you were signing. 2, frustration arises without the fault of any party, right? So big picture events we could be looking at, of course, natural disasters, acts of war, things like that, would generally qualify, unless it is the act somehow of one party. But I don't think that would be an easy connection to make. So it's not frustration if one party decides to sabotage the other. It's not frustration if one party has to deliver goods to the other and the other party is no longer willing to pay the newly increased price of you as a supplier. So, you tank your own ship and you're like, I'd rather these goods, drown in the sea than be delivered for 1/10 of what they're worth, and I'm robbed by my business partner. That's not frustration. That's you doing very unreasonable things, for which there's a chance you will be held legally liable for. The third factor, for which the parties made no express or implied provision in the contract. So there are nowadays, post-COVID, we see language in contracts which actually accounts for frustration. Not in the sense of predicts exactly what will happen, but predicts general genres of frustrating events and stipulates what will take place if that happens, right? How long will it take to recover? How long do we take to make a decision? How much money? Who's responsible for what if a natural disaster happens? Things like that. So frustration, generally speaking, we're looking at scenarios that we haven't covered in the contract. And lastly, I mentioned there's 4 criteria. The 4th is that it renders performance of the contract radically different from what was originally contemplated, right? So it's not frustration that something costs 10% more. It's not frustration that something takes an extra 3 days to come. Generally speaking, It is frustration that, something is just impossible to happen anymore. You were going to ship goods through the ocean and the ocean dried out and now you can't. That is a frustrating event. You were going to sign for a commercial lease and an earthquake happened and the ground swallowed whole the factory that you had signed for. That is a frustrating event. We cannot bring that factory back, at least anytime remotely, plausibly soon, under general, contractual and legal expectations. Frustrating events are big picture, big boy issues or big girl issues, and they also, as not necessarily one of the 4 criteria, but a pattern we see coming out of case law, is that frustrating events have to do with permanent impact, if you will, not temporary. So like I mentioned, it's not a frustrating event if something was just going to come 3 days later, like the same exact deal is going to take place, but it's delayed. It has a temporary delay. Frustration is a full stop to either of the parties or both of the parties or one of the parties being able to carry forward their contractual obligations as the parties had agreed to doing. A second term I'd like to look at is the term inter alia. I want to be careful to distinguish between categories of terms. For example, frustration is a heavy-hitting term that might show up at only one part of your contract, but it's something that if a frustrating event ever occurs and you're trying to argue that in court, that single paragraph in an entire, whether it's a 5, 10, 50, 100-page contract, is going to be a make or break. But then there are terms in the contract that are confusing that still matter a lot, owing to not necessarily significant per se. They might not hold as much significance on their own. However, owing to the frequency we see them in the contract. In other words, they show up so much that inherently they will matter in the big picture. And these are important terms to know in the big picture. And one such term, depending on the lawyer that's drafting your contract, some lawyers prefer to use more modern language, different sentence structures. Some lawyers prefer to use more classic legal terms. And this term that we're about to go into leans more on the classical side. It's an old Latin term, and the term is inter alia. You might have seen a contract sprinkled with this term and signed being like, I'm just so embarrassed to even ask what this means. Well, this is why you should know what inter alia means, because inter alia means among other things, big picture, right? It is that classic lawyer language of includes, but is not limited to, that kind of situation. However, inter alia can mean a lot if you think you're signing up for something that, for example, certain things are expected of you, and the sentence says thing 1 and thing 2, comma, inter alia, comma, are expected of you. So if you read that without asking clarifying questions as to what inter alia means, you might think that think 1 and 2 is all that's expected of you. However, the lawyer or the individual on the other side has made sure to cover their bases by putting the term inter alia in there and making it so that it's not just the 2 things. Remember, in the hypothetical sentence, we gave thing 1 and thing 2. It's not just those 2 things. Actually, it's a host of other things that if you're asked to do and you say, well, it's not one, you're not asking me to do the 2 things you explicitly stated, then the other side says, well, I'm actually asking you to do something similar to that, something equally important, and that's covered by my lawyer's use of the term inter alia. So again, it's a term that in and of itself, putting inter alia on a blank page means nothing, quite literally, but putting inter alia in a sentence where there's a list of expectations on you as a commercial tenant, for example, expectations on you as a commercial partner, expectations on you as a vendor, somebody that's selling something or supplying something and you're expected to deliver it by a certain time, inter alia, these other conditions as well. So understanding and asking clarifying questions as to what could be covered by that term inter alia, or the English meaning of it, meaning among other things, what could be covered by that as per the context of your contract, asking that question to your lawyer. Keeping in mind again that this video is not legal advice, this video is educational and informational. So you take all this content and when you're in front of a lawyer, you make all that much better use of your time, save yourself some money through saving yourself the time, and you ask these clarifying questions. A common everyday example to use inter alia as well, although you can imagine it would be funny to hear this, but you can use it outside of legal context. You might hear somebody talking about a grocery list. So the grocery list could include bread, milk, and cereal, comma, inter alia. Wouldn't context matter if, you know, you identify as male watching this video and your wife is asking you to go to the grocery store? Well, you are going to likely be going there within the context of what your family finances are, what your, you know, family cravings and appetites are. So for somebody, that bread, milk, and cereal, comma, inter alia, might be filled in with, you know, caviar and champagne. For somebody else, after bread, milk, and cereal, comma, we might have, you know, chips and Coca-Cola. So understanding that concept, you can imagine how one choice is a lot more costlier than the other. One choice is going to cost you a lot of time and a lot of fighting and a lot of arguing with your partner back and forth. Why'd you buy this? Why'd you buy that? Even in the colloquial sense, we're not even talking about the contractual definition right now. So you can imagine how in a contract, what the other party expects by using inter alia and what you have understood it to be. It's really important that those two sets of expectations align, because a lot can go wrong, and you're just going to end up, you know, with costly legal battles at that point, arguing that this shouldn't have been covered in the same category of inter alia, and the other party's obviously going to say, well, it was inherently covered and you didn't bother to ask, and, you know, why would you sign if you were worried about this thing and all that. So all things to think about. The term inter alia, again, being a term that there are contracts where I see this term come up like every other paragraph, because for convenience reasons, right? We're not going to list out every single thing. And also as a lawyer, chances are you wouldn't want to do that for a client anyways, because it could mean that what you didn't list will be used against you. So lawyers try to use this language to protect their clients. But you have to protect yourself as, you know, you're watching this Graphene Business Law YouTube video, and hopefully this puts some ideas in your mind as to how to protect yourself by asking your lawyer all of these questions you might not have thought of in the past, okay? I'll leave this video there. Let us know in the comments below what you thought about this video. Our YouTube community here on Graphene Business Law is slowly growing, and of course, we welcome your feedback, and it's one of the best ways that you guys as subscribers can help each other grow, and that you help us grow here as well. You give us things to talk about, things to think about, things to talk about in next videos, and help even more people with our content. Again, thank you so much for watching. Like this video, click on the subscribe button down below, and we'll see you next time. Thank you for watching.